Welcome to the Gambone Law Podcast, brought to you by Gambone Law, a Philadelphia-based criminal defense law firm. This weekly podcast is based on questions that we have received from clients in the area of criminal defense with a focus on Pennsylvania and New Jersey law. It is my sincere hope that this podcast will help you and your family make better decisions and help you understand your rights under the Constitution. Our law firm is committed to providing the highest level of professional service to its clients and their families. We strive to not only provide aggressive advocacy, but serve as a trusted advisor to individuals during a difficult time in their life. To learn more about our law firm, read my weekly blog, watch my instructional videos, or download a copy of my free strategy books, visit gambonelaw.com or call 215-755-9000, 24 hours a day, 7 days a week. Well, hello again. Welcome to the Gambone Law Podcast. This is episode 5. Every week we discuss a different issue in criminal defense. This week I'm going to be discussing sentencing. Now, most of our cases, obviously, we want them to result in an acquittal or dismissal or discharge of the offenses or the crimes that you were charged with. But there are situations, obviously, where we have to negotiate a plea or a person is convicted following a trial. Like all attorneys, despite what you may find on the internet or in newspaper ads, or if you still read those, or in advertisements, no attorney is 100% wins all the time. So with that said, it's important to understand that sentencing is obviously something that we have to deal with every day. It's a very important procedure that you should understand if your case is going to go to trial, and obviously if your case is not going to go to trial. You have to understand that the majority of criminal cases do not go to trial, like the majority of civil cases don't go to trial. It's over 90% of cases, both in the criminal world and the civil world, result in either a settlement in the civil world or a plea in the criminal world. So let's talk about sentencing. Like always, I'm going to take some questions from our clients in this area. The first question is, are all legal crimes involving the illegal possession of drugs or guns graded as felonies? Is there a substantial difference between a felony conviction and a misdemeanor conviction? Well, this is a very good question, a very common question, an area which you must understand. Most people believe that crimes are crimes, and that's simply not the case. There is a substantial difference between a felony conviction and a misdemeanor conviction. While a felony conviction carries with it a presumption, some would say, of incarceration, state, or even a county jail sentence, that's not necessarily true in all cases. You can be convicted of a felony and not serve any jail time at all, and just receive a period of probation, and that can range depending on the offense or the crime that you've been charged with and obviously convicted with. A misdemeanor, again, you can serve a state or county prison sentence. It's more likely that you'll serve a county jail sentence. In addition, obviously, you can receive a probation sentence. Most people, the first question they ask me is, am I going to go to jail? And what I tell them is that the analysis just can't stop there. You can walk out of court and not serve 1 day in jail, but receive a felony conviction, and that can substantially alter or hinder your professional and educational opportunities in the future. You have to understand that with a felony conviction, one of the major things that it will prevent you from doing will be owning or possessing a firearm. So if you have a felony conviction in Pennsylvania or New Jersey, you won't be able to ever possess or own a gun or firearm, and that will not change. You also can't have a felony conviction expunged or sealed or anything like that. It will stay with you. From an employment standpoint, a felony conviction, most employers can and will look at it much differently than a misdemeanor conviction. Examples of felonies are possession with intent to deliver drugs, most gun offenses, aggravated assault, robbery, burglary, obviously crimes like murder. There isn't an issue there. With regards to misdemeanors, there's still criminal convictions, but those convictions are much less serious, and in in many ways, many employers will often look past them or give you an opportunity to explain. Whereas with the felony conviction, it more than likely means that you either served some jail time or you received a substantial period of probation. It also would prevent you from doing a lot of other things that employers may take into account when making a hiring decision. With a misdemeanor conviction, you have to understand that it usually won't prevent you from owning things like a gun or applying to certain government programs or even government jobs. Even military service. A felony conviction will often prevent you from serving in the military, while a misdemeanor conviction, depending on what it is, you may be able to receive a waiver to still go into the military. So that's very important. You have to understand that a felony conviction, you can't always look at, am I going to jail or not, but whether or not your offense is being graded as a misdemeanor or a felony. And it's also an opportunity for you to talk to your attorney about what can be done, if anything, to mitigate that crime, or possibly even have a plea agreement which calls for the amending of the charges and have you plead to something less serious. So pleading from a felony to a misdemeanor, even if it requires you to maybe serve some more probation or even something like house arrest. In many situations, it's often better to have the misdemeanor conviction rather than the felony. So I can't stress that enough. Don't just look at the maximum sentences. Okay, another question. How do judges determine sentences? Well, you have to understand that judges don't simply pick sentences out of the sky. They have to use a reference point. And the reference point in Pennsylvania is something known as the sentencing matrix. And what it is it's a table. And on the horizontal axis of the table is a person's prior record score. And it's simply using numbers, anything from a 0 up until a 5. And a 0 would mean that you have no prior criminal history. On the vertical axis of this table, you have what's called the offense gravity score. So on the horizontal axis, you have a prior record score. On the vertical axis, you have an offense gravity score. And on that offense gravity score side, you have everything ranging from a very minor offense like the simple possession of drugs to murder. So all those offenses are on that table. And I don't want to get into mandatory minimum sentencing, but just think of it that way. So it covers a variety of offenses, and it goes from low of 1 to as high as like 14. And within those tables are recommended sentences. Now, also within this table is a portion of the table devoted to aggravation and mitigation. And this is where the judge can deviate from the recommended sentences. So taking a crime like the possession with intent to deliver drugs, well, the offense gravity score in that can range from something as high as a 13 to as low as, say, a 5 or a 6. And really that depends on the weight involved. So if you're charged with selling a substantial amount of heroin, for instance, what is known as a Schedule I controlled substance because it has no medical use, that would be graded very high on the offense gravity score. So you're looking at a substantial state prison sentence. Whereas if it was a lesser amount of heroin or some other controlled substance, it would be graded lower. So you would face a much lower potential criminal penalty. So it's important for you to understand that if you're entering into a guilty plea negotiation with the district attorney's office, you have to understand your offense gravity score, your prior record score, and how that is determined. Your prior record score is based on your prior criminal history. Typically, for most felony offenses, you'll receive at least 2 points, and in some cases even more points for just one conviction. So if you have a prior conviction for a possession with intent to deliver drugs, typically you'll have at least 2 points. So that will increase your sentencing guidelines. So a person who has 2 prior record score points will face a much harsher sentence than a person who has no prior record score points. So your attorney should explain that to you. You should also understand that with regards to a plea, you should be able to evaluate a plea offer based on those guidelines. If your attorney cannot speak to you intelligently about those guidelines, you simply have the wrong lawyer. And I'd highly recommend seeking a second opinion. You should never walk into a plea and just take a plea because the lawyer tells you this is a great deal. Don't go by the maximum sentence, because you'll find that, for instance, a maximum sentence in Pennsylvania, a misdemeanor of the first degree for a crime like terroristic threats carries with it a maximum sentence of 5 years, while a misdemeanor of the third degree would carry a maximum sentence of 1 year. A felony of the third degree or an ungraded felony would cover would result in a maximum sentence of 7 years. So if your attorney tells you, for instance, you face a maximum penalty of, say, 25 years in jail because you have multiple ungraded felony charges, or, for instance, a felony of the second degree where there's a 10-year maximum sentence. There are some cases where the attorney may tell you, well, look, you face 30 years in jail. The plea is for 2 to 5 years. You should take it. I would highly recommend looking at your sentencing guidelines and asking your attorney about those sentencing guidelines first before entering in that plea. You have to understand those numbers and also understand the judge's sentencing philosophy. Your attorney should understand this judge. Every judge is different. Judges aren't robots or human beings. Your attorney should understand that judge. What is his or her background? Are they former prosecutors? Are they former defense counsels? If they were private practicing lawyers, what type of firm did they work in? If they're criminal judges now but worked in a civil firm and weren't prosecutors or defense lawyers, that may tell you something about their sentencing philosophy. If they were former prosecutors and never spent a day on the defense side of the courtroom, again, that may guide them in terms of the type of sentencing that they may fashion. And that's all important. There are exceptions. There are former prosecutors who become judges who are very lenient judges. There are former defense counsel who become judges and are the harshest judges that I've been in front of. You can't always go by the person's prior employment. Next question. Okay, this has to do with a plea. I am thinking about taking a plea deal to the charge of possession to deliver drugs. The plea would require me to serve a county jail sentence of 11.5 to 23 months in county jail. I have a criminal history but no felony convictions. Is this a good deal? My lawyer told me the maximum punishment is 7 years of state prison, so it sounds very good to me. Well, again, this is a perfect example of looking at the sentencing guidelines. And also from this question, I have no idea how much drugs that we're talking about from this question. Is it a kilo of a heroin? Is it 1,000 pills? Is it a small amount of heroin? The fact that you're charged with possession intent to deliver drugs and convicted of it doesn't tell me how much weight is involved, because the weight will dictate the sentence. So you have to understand that. In addition, this particular question references the maximum sentence. Again, it's very highly unlikely that you will receive the maximum sentence. In fact, I can almost guarantee you won't. Judges aren't going to sentence based on the maximum. They're going to sentence based on sentencing guidelines. So for this particular example, looking at it, the question, looking at it, I would say that you need to know more. And I would encourage you to look up my website. I have several blog articles on sentencing, both in Pennsylvania and New Jersey. My website, gambonelaw.com, in addition, has all of my strategy books. Also, you can find links to my videos, instructional videos. I believe that I have some videos on sentencing and other issues which are important to a decision like this. It also explains things like open pleas versus negotiated pleas. Next question. What is the difference between an open plea and negotiated plea? So I kind of got into this a little bit. An open plea is where there is no negotiations between your defense counsel and the Commonwealth, or the district attorney's office who represents the Commonwealth in Pennsylvania. In New Jersey, it would be the state. So with a open plea, your attorney is going to make an argument, and and the prosecutor or assistant district attorney will make an argument as well. The judge will hear those arguments and then determine a sentence based on those arguments, as well as considering things like your offense gravity score, your prior record score, your sentencing guidelines. And within those guidelines, there's room for mitigation or aggravation. Now, the tables give recommendations to the judge. The judge is not bound by anything. Obviously, both the defense and the prosecution, if they feel as though the sentence was too harsh or too lenient, can both appeal the sentence. And you have some options there. In Pennsylvania, you will find that you have 10 days from the date of your sentence to file a motion for reconsideration with the judge, and you have 30 days to file an appeal to the appellate division of Pennsylvania, otherwise known as the Superior Court. And those are some options you have. But going back to this example, with an open plea, it's an argument based on the guidelines, and your attorney can introduce various pieces of evidence to mitigate your sentence. The most common ways to mitigate sentences are to show a person's strong work history, what they've done in the community, what they've done for their family. And these are all things, hopefully, which can help you or a friend who is facing sentencing. Military service, obviously, is also something that I highly recommend speaking about at sentencing following a conviction. So basically, your attorney wants to point out all the good things that you've done throughout your life, however insignificant you may think they are. It's important that you put them out there in front of the judge. And in addition, you also have the opportunity to have someone speak on your behalf, whether it be friends or family. And in many cases, the prosecution will not object to you submitting letters. Normally, you can't do that in court. You can't just submit letters and not have the person come in and testify. That's what's known as hearsay. Without getting too far into evidence, what I would tell you is that the letter can be introduced. The judge can be allowed to read it and then consider it. Normally, when you want a judge to consider evidence in the form of a person's statement, it has to be in the form of testimony. So letters, a person can come in live to speak to the judge about all the good things that you've done in your life. Now, the prosecution gets an opportunity to cross-examine those witnesses, and you have to be aware of that. On the other side, the prosecutorial side, you have to understand the prosecutor is going to introduce whatever it can in terms of aggravation. It's going to speak about the crime. If there's victims, they may have the victims come in and give what's called victim impact statements. And they can do the same thing except to try to aggravate the sentence. And they ask the judge for obviously a more harsh sentence than your defense attorney would ask for. The decision to go open or negotiated, it's a lot of factors. A lot of it could be simply that your attorney believes the judge will go much lower than what the ADA is offering. It could be that it's unlikely that you'll be acquitted at trial, and that the offer from the DA's office is simply nothing harsher than you would receive had you been convicted at trial. But at least if you plead open in front of the judge, your attorney can argue that you accept the responsibility, and that can be very powerful. If you have a trial, and especially if you take the stand in your own defense and do something like obviously deny it or somehow justify it, and the jury or judge alone convicts you of it, your attorney can't turn around then at sentencing and say, well, judge, he or she has taken responsibility. It doesn't hold much water at that point. With a negotiated plea, the judge isn't bound by the plea negotiations. He or she can refuse to accept the plea and simply tell you that you can either go to trial or plead open in front of the court. Most people at that point would probably go to trial. But with the negotiated plea, in most situations, both in Pennsylvania and New Jersey, it is very likely the judge will accept the plea negotiations because the judge understands that the negotiations have been entered into on both sides for various reasons, typically because the prosecution knows it may have a little trouble at trial with some charges, and the defense knows that if it went to trial, there's a strong possibility that the case would result in a guilty plea a conviction. So the judges understand that. Judges are attorneys. In addition, many of them have practiced for years. So they understand how the system works and that pleas are obviously a part of it. Okay, let's take another question. I'm going to reach down here. Okay. My lawyer tells me that the ADA will ask the court to impose the deadly weapon enhancement if I'm convicted at trial. What does that mean? Well, what this question is probably talking about is a case where the person is likely charged with a gun or firearm. But in Pennsylvania and New Jersey, pretty much anything can be a deadly weapon, but usually in most of these cases, it's typically a gun. And previously I explained about sentencing guidelines. Well, in Pennsylvania, they have something known as deadly weapon enhancement. This is a separate table. It's actually two tables. One table is for the possession, and one is for the use of a deadly weapon. The use is a much harsher table in terms of a sentence, while the possession is not as harsh. Typically, it will raise sentencing guidelines from as much as 3 to as much as 6 months to as much as a year in some cases for an offense. So, for instance, a typical situation is where a person is charged with, say, terroristic threats, and the person has no prior criminal history. So in this situation, the standard guidelines would call for what's called restorative sanctions to 1 month of county incarceration. And with something like that, while the guidelines call for up to 1 month of incarceration, usually I would say that it's unlikely you will serve any jail time. You will typically serve a period of probation. With the deadly weapon enhancement, that could substantially raise those guidelines. So for possession alone, it could probably raise the guidelines to as much as 3 to 6 months, I believe. And for use, I believe it would go to 6 to 12 months. So you'll see for that charge where typically the guidelines would call for probation, now you're looking at a much more of a substantial county jail sentence. With regards to use and possession, the DA has to tell your attorney that they're going to seek that prior to trial, and you have to be aware of that. It should factor in your decision, but just know that the judge isn't bound by the guidelines. He or she can deviate from them. The only thing is that when they deviate, they're subject to obviously the prosecution appealing that sentence. Some prosecutors are inclined to do it, others aren't. That's really a discretionary decision. But that's what that's referring to. The deadly weapon enhancement is something that will just aggravate your sentence and could be a consideration with regards to whether or not you enter into a plea or move forward in the trial. So all these concepts are very important to your defense. I can't stress enough that our law firm does so much to provide information to you, things like this podcast, my weekly blog, my books, my videos. These are all things that we provide to you, our clients, our prospective clients, and their families. We want you to be informed clients. We want to understand your rights in Pennsylvania and just really under the Constitution in general. It's very important. I believe that an educated client is in a position to achieve a much better result than a person who simply walks into court and just just doesn't really have an understanding of the system itself. I'm not telling you have to have a law degree, but you have to understand what's happening. And you should question your lawyer. You should also, your attorney should have resources available to you. You should not be afraid to ask your attorney a question. If your lawyer is barking back at you that he or she is too busy, we all get busy, but there should be resources available to you. I want to thank you again for listening. I look forward to speaking with you next week. So just one final point. If you like this podcast and like this video, just ask that you like and subscribe to our podcast, and you'll be notified when future videos appear. Also, if you want to shoot me a question, feel free to do so, and maybe I'll answer it on the next podcast. My email address is alfonso, ALFONSO, at gambonelaw.com. You can also visit our website, and you could fill out a downloadable form there. And also call our law firm at 215-755-9000. Again, 215-755-9000. That is a 24-hour number. And our law firm's website is gambonelaw.com. And it'll take you right to all the information that we have available to you.